We have Justin Ciccolo, who is the founder and president of BitAML and the executive director of the California Blockchain Advocacy Coalition, also known as CBAC. CBAC. All right, where we go. This is Joe.
Hey, everyone. Thanks. Thank you. Hi, everybody. Joe Ciccolo, as was mentioned, I'm the founder and president of BitAML. We provide regulatory compliance consulting services to the crypto space. And I'm also the executive director of the California Blockchain Advocacy Coalition. We are a nonprofit trade association representing the interests of crypto and Web3 before the California Legislature, Governor's Office, and various different state regulatory agencies, which is going to be the focus of my talk, talking a little bit about DFAL and what we can expect. So just to kind of lay the groundwork, people all of a sudden we're starting to regulate crypto in California. What happened? It's been years of missteps and just honestly setbacks in terms of setting the regulatory table in California with various different events happening in the marketplace and some missteps. Wait to see what's happening at the federal level, but all that to say, and fast forward to today, we are going live with licensing in California on July 1st. So a little bit of background here to kind of explain that. Back in 2015, so California started the path of licensure and regulated crypto back in 2015 with an ill-fated bill. It was overly broad and could have scoped in a lot of developers and a lot of folks that really shouldn't be regulated, in my opinion, for digital assets, digital financial assets. Fast forward in 2022, we had the Grayson bill, which made it all the way through the legislature, made it to the governor's desk, and the governor vetoed that and said there's some issues about ambiguity and timing and what we're going to wait for in terms of federal policy. Unfortunately for the governor, he had a bit of bad timing because when he vetoed that bill, two months later, FTX collapsed. And so it became inevitable that we were going to have a bill in 2023 no matter what. And we need to do that going into that particular year. So we'll rewind in 2022, again, that bill that we thought was going to be law. In the midst of all that, the Terra Luna collapse happened. So if you actually go back and look at that original bill, you could see a lot of the redlining on or around May of that year. After Terra Luna collapsed, the lawmakers were trying to get in there going, we need to regulate stablecoin issuers, right? And so they had all this redlining. When it got to the governor's desk, he's like, what is this? Looks like a piece of art. So he eventually vetoed that. And unfortunately, like I said, 2 months later, FTX collapsed. And the industry said, hey, we're going to have to move forward to licensure in 2023. So there we go. Well, can we go back one? There we go. There's a blurry picture of me testifying. So very auspicious start to 2023. As you can see by the title of the hearing, harmful innovation. I don't really like that beat of the title, right? So you can tell already we're on the defensive as an industry. And of course, I couldn't help but mention FTX and Chair Grayson, who chaired this meeting, was making a point to the governor that, hey, you had my bill and you didn't sign it. Then FTX happened, which was kind of a cheap shot at the governor. But his point was we need to move forward with something because things are going on in the industry and we need to find out what good regulation looks like. Oops. Pointing at this guy, there we go. So let's talk a little bit about DFAL. DFAL has two parts. It's actually two bills. I want to focus more attention on the AB 39 in the interest of time and focus. So AB 39 is the actual licensing aspect of the bill, the overarching licensing of digital financial asset businesses. So it created this comprehensive framework. Originally in the bill, it was set to go live July 1st, 2025. There was another bill after that kicked the can another year because the state apparently wasn't ready. So that's where we are today. But again, he's setting the tone for licensing, what it looks like. And if you look at the legislation, we'll talk about it in a minute, most of what you can expect as an applicant or even as a consumer, frankly, is in that statute. A lot of the work was done by the legislature and the DFPI has admitted as much. By the way, there in the governor's signature letter, the governor has the opportunity to put a signature letter of any piece of legislation that he signs. And in that letter, he said, hey, look, we're going to sign this. It's really important. But at the end of the day, we have to go back and maybe smooth out some of the ambiguity. We could talk about, if we have time, some of the cleanup legislation that goes with that. Let's see. There we go. Second half of the bill was SB 401, very focused regulations and limitations on crypto ATMs. It's a bit of a dying business in terms of market reach and a lot of very sort of aggressive state licensing and aggressive requirements and legislation have really reduced this industry. But ultimately, there was a separate targeted bill focused on the ATMs, and that's under DFAL. So when sometimes people hear DFAL, they think of licensing, but it's also the ATMs as well. You can go to the next slide. one more. So a lot of information on SB 401. Again, crypto ATMs, so capping fees at 15%, $1,000 per person per day, and then some consumer protection aimed controls, warnings, kiosk locations, things of that nature. What I find interesting about this and what is useful for our thinking about the actual licensing bill, because that's coming up real soon, is the aggressiveness of the DFKI, the regulator in California. They were really aggressive right out of the gate in going after these kiosk operators for, among other things, not adhering to the $1,000 per day daily limit or the fees to get a fee cap and some of the other aspects of this legislation. So in the actual legislation, there is a $2,500 per offense fine. And so what the DFAL was doing is they were totaling up how many times a particular unit, a particular kiosk, was in violation of that. If you multiply all the different transactions by all the different kiosks, some of these operators there, it's all public information, some of those operators there that were subject to enforcement actions had $500 million fines. People were saying, that's outrageous, that's ridiculous. Well, what the DFAI did is they actually just took the statute and said, we have $2,500 per offense, let's just total this up. And if you read the enforcement actions, they actually did the math in there. And so it gives them a pretty strong point for which to negotiate these enforcement actions. And I'm worried that that'll cascade over into licensing of the industry at large. So let's get into AB 39 if we can. Awesome. So again, this is the overarching legislation of licensing, robust consumer protection, emphasis on cybersecurity. We don't hear a lot of cybersecurity regulation for money transmitters, particularly crypto and traditional money transmitters. A lot of the states don't have specific requests or specific legislative items, I should say, on cybersecurity. California kind of upped the ante on that one in terms of that being an area of focus. And some other requirements, as you can see, financial stability. I think we'd all like to see businesses have financial stability. And then specific requirements for stablecoin users. That's no longer the case because of the Genius Act. It's effectively been wiped out. For the nerds that are out there, because I heard there's some here, that's Chapter 6 of AB 39 is the stablecoin issuers. So if you wanted to look that up on your own time. So yeah, licensing requirements. So talking to Deputy Commissioner Vernon Lear, she had mentioned, among other things, wanting to be really public in their engagement. They're wanting to build the state-of-the-art for government, her words not mine, state-of-the-art for government licensing intake process to really help people go through that license process, recognized as applicants where they are, rather than have this sort of tone-deaf silence that we saw in New York or the BIT license. So I think there's a lot of lessons being learned and applied. The license went live on March 9th, so it's out there for companies that have access to NMLS. And again, we're dealing with some of the things that the governor pointed out in signing the bill. When he signed AB 39, he said, look, I think we got to smooth out some of the ambiguity with regard to what businesses this covers, definitions of control, best execution. Again, super nerdy stuff. So just real quick, this was the bridge bill that kicked the can one more year, AB 1934. That moved the date from 25 to 2026. But more importantly, 2027. Whoops, can we go back one? Sorry. There we go. SB 97, that's the so-called cleanup bill. So that was the governor's request. Again, the offer is under no obligation to go forward with any sort of cleanup bill. But in this case, Chair Brayson is very diplomatic. He said, okay, let's put together a cleanup bill. Let's work on all this stuff. We got together, we sat down with all the stakeholders and said, hey, this is what makes sense for best execution. This is what control means. This is who it should apply to. Everything was going great, and then we got the Clarity Acts being delayed. So now our cleanup bill is delayed. So we're moving forward. DFAL is not perfect. It's far from it, but those are the cards we're going to have to play. So let's talk about preparing for DFAL. So I don't know if anybody here has their application ready, but we could talk about some of the elements of what's going to go into that and what one should expect. And I think it's important, too, for consumers to see what they might expect as well. So it's being submitted through NMLS. I think folks who are involved in state and MTL, money transmitter licensing process are already aware of that. That's sort of the vehicle for bringing in the application information and uploading all the requisite documentation. Again, points of emphasis on what you're going to be evaluated on, financial condition, your ability to be compliant long-term. That's a huge deal. Anti-fraud, consumer protection. Consumer protection, by the way, California is basically the consumer protection capital of the United States. So we have some of the toughest consumer protection laws, anti-jump fee laws that you can think of. So guess what? That's what they're going to focus on. And having clear escalation, investigation procedures is important. Again, I'm summarizing some of the stuff that some of the old salts and compliance probably argue a lot about. And DFPI wants to see that you've tailored your expectations. We've been told that actually during the application process, you're probably going to have to demonstrate or be able to test in this sort of mini exam type of format that your controls actually work. Ultimately moving beyond the paper policy, having something actionable. So Amber is correct in many ways, and then one of those is we're not going to have paper binders, we're not going to have static PDF policies, but we're actually going to have a regulator who says, hey, that policy reads well, sounds good, looks good on paper, but let's talk about practice. Let's have a look at that in real time. All right, so yeah, a few other points of emphasis here. Sort of expectation, cybersecurity. I mentioned that was a huge component and a huge point of emphasis from Deputy Commissioner earlier. Making sure that we cover strong frameworks with respect to anything like smart contracts, wallets. From her perspective, and the perspective of the regulators, it's the cyber environment that we're dealing with. These are all digital, right? So we would expect cybersecurity to be strong, and I'm very surprised, and I remain surprised that a lot of the other states haven't been strong in terms of their expectations in terms of cybersecurity. I think California is going to set the tone for many other states going forward. So some of the different, other information, I find this to be pretty valuable here. There's no dedicated no action, I don't love that term, no action or determination framework. So if you think you're the exception to the rule, there's no choreographed process for that. You just have to reach out to the regulator. There is an expectation that you do some coin due diligence and have that certified by an officer of the company. By the way, if you don't, it's $20,000 per offense per day for the coin due diligence certification. That is one of only 2 fines. The other fine is not being properly licensed. So that shows how important that is. Applications must be accepted to remain operational. So if you exist today as a crypto money transmitter in California, you don't need a license, right? But in order to keep that, in order to continue to operate, you must have not only submitted your application, but it must be accepted by the regulator, meaning that it has all the components of that letter, or all the components of the application, excuse me. So if you don't have that have that accepted, you could be putting yourself in a position for a $100,000 per day fine as an unlicensed money transmitter. So there's a big difference between submitted and accepted, and that's something that Brendan has told us to tell everybody that we talk to, because it was a huge, huge difference and one that could be very costly. And I have some information about the fees up there and fines for, as I mentioned before. The most common oversight, the DFPI told us, this was actually last week, they told us the most common oversight they're seeing, and they're getting a lot of applications already. Again, for the compliance nerds out there, from AB 39, that's your citation. Essentially, it's specific information about the percentage of your customers in California. And that's the analytic statute, if you want to look that up. All right, so let's prepare applications together. So review the resource page of DFPI. They put out a lot of information. They put out FAQs. They put out a checklist. It's very voluminous. I mean, you're going to be scrolling a long time in that checklist. There's a lot of requirements, but they're spelling them all out. They're choreographed this. And as they told to us, they watched the mistakes in New York with BitLicense and said, we're not going to do that same thing. We're going to be transparent. We're going to put information out there. Yes, we're going to be tough. Yes, we're going to hold ourselves out to the California standard. But understand at the end of the day, we're going to be transparent. We're going to talk with the industry and make those connections. So if they felt enough to put that resource on their website, I'm going to say it's going to be very important. Organizing their points of emphasis, I mentioned this before, consumer protection and cybersecurity are probably the 2 biggest. Again, that doesn't mean we're going to discount the other elements of the risk management spectrum, but these are 2 areas that stick out and maybe aren't as recognizable in other states by comparison. So engage in industry trade associations, a little shameless plug there for CBAC, but in all seriousness, wanting to engage with others in the space. So if you don't want to put your own company name or your company face out there, trade associations are an excellent vehicle to be able to make those connections and work with some bar members like Idris Porowitz, Coinbase, Kraken, CoinFlip, Polychain Capital, and other companies that we represent. And of course, carefully weigh the benefits of when you want to apply, right? Sometimes you want to wait. Hey, let me get everything together. I'm not quite ready. My mom told me a long time ago, it's never the perfect time for anything, right? So figure out what that timing is, and please do not wait. And stay tuned for the legislative session. And if anyone's curious about any of the current legislation that's out there, well, that's a different presentation, but I'd be happy to follow up offline and share some of the Bs and bills that we're following this year. It's great for once to be on the offensive and not on the defensive of the California legislature, so it'd be my pleasure to talk about some of the things we're working on in the current session. with some amazing representatives. Adelina Valencia from Anaheim is probably the unofficial crypto capital, our crypto sort of leader in the state house or state capitol, and followed by Chair Grayson in Sepik Place. But there are many emerging leaders in our capital that want to be right by the industry and want to hear from all of you.